Good afternoon, friends. Sometimes there is question in the Advocate General Court examination of Supreme Court of India regarding types of jurisdictions of the Supreme Court of India. So I am diving into that era. Friends, the jurisdiction of the Supreme Court can be broadly categorized in various forms. First one is appellate jurisdiction. We generally file appeals permitted from or under Article 132, 133, 134 of the Constitution, read with orders 19 and 20. This comes under the appellate jurisdiction. Secondly, appeals arising out of statutes or any other law for the time being in force, orders 19 to 24 deals with that. Then comes appeals under Section 2 of the Supreme Court, Enlargement of Criminal Appellate Jurisdiction Act 1970, read with Order 20 of the Supreme Court Rules 2013. Then comes appeal under grant of special leave to appeal under Article 136 of the Constitution, read with Orders 21 and 22 of the rules. Then comes extraordinary appellate jurisdiction. Petitions for special leave to appeal under Article 136 of the Constitution. This is also read with Order 21 and 22 of the rules. Friends, then comes the original jurisdiction. Petitions under Article 32 of the Constitution, read with Order 38 of the Supreme Court rules for issue of directions or orders or writs, including the writ in the nature of habeas corpus, mandamus, prohibition, quo warranto, certiorari for enforcement of fundamental rights. Then comes under original jurisdiction, original suits under Article 131 of the Constitution, read with orders 25 to 37 of the Supreme Court rules. Then comes under original jurisdiction, petitions under Article 139, capital A, subclause 1 of the Constitution, read with the order 40 of the Supreme Court rules. Then comes petitions under Article 139, capital A, subclause 2 of the Constitution, read with order 41 of the Supreme Court rules. Then comes petition under Article 25 of the Civil Procedure Code 1908, which is read with order 41 of the Supreme Court rules. Petition under petition under Section 406 of the Code of Civil Procedure 1973, read with order 39 of the rule. Then comes petitions under Part 3 of the Presidential and Vice Presidential Elections Act 1952, read with Article 71 of the Constitution and Order 46 of the Supreme Court rules. Then comes petition under Section 11, subclause 1, subclause 5 of the Arbitration and Conciliation Act 1996, read with the appointment of arbitrators by the Chief Justice of India scheme 1996 relating to appointment of an arbitrator. Now, friends, there is also extraordinary original jurisdiction. Petitioned under Article 32 of the Constitution, read with Order 38 of the Supreme Court rules, like public interest litigations. Now, friends, let us discuss advisory jurisdiction. Reference by the President under Article 143, Subclause 1 of the Constitution, read with Order 42 of the Supreme Court rules on the question of law or fact of public importance. Reference by the President under Article 143, Subclause 2 of the Constitution of India, read with Order 42 of the rules of a dispute of kind mentioned in the proviso to Article 131 of the Constitution. Reference by the President under Article 317, Subclause 1 of the Constitution, read with Order 43 of the rules in relation to an inquiry for removal of chairman or any other member of the Public Service Commission from his office on the ground of misbehavior. Then comes the reference by the President under Section 14, Subclause 1 of the Right to Information Act 2005, read with Order 43 of the rules. Reference by the Governor under Section 17, Subclause 1 of the Right to Information Act 2005 or any statute under Order 43 of the Supreme Court rules. Then comes the reference under Order 44 of the Supreme Court rules by the central government or statutory tribunal under the statute. Reference under Section 257 of the Income Tax Act 1961, read with Order 45 of the Supreme Court rules by the Income Tax Appellate Tribunal through its president. Friends, there is also an inherent and plenary jurisdiction. Petitioned under Section 3 of the rules to regulate proceedings for contempt of Supreme Court Act 1975, read with Article 129 and Article 142 of the Constitution. Then comes application for review under Article 137 of the Constitution, read with Order 47 of the rules. Then comes curative petition under Order 48 of the Supreme Court rules as per law laid down in the case of Rupa Ashok Hura versus Ashok Hura and another, that is of 2002, Volume 4, SCC at page 388, to prevent abuse of process of the court and cure gross miscarriage of justice. Then comes application under Section 2 of the Supreme Court Decree and Order Enforcement Act 1954. So friends, these types of jurisdictions are of the Supreme Court. There can be question from any part, whether they may ask for appellate jurisdiction, they may ask for original jurisdiction, they may ask for a reference jurisdiction, they may ask for inherent and plenary jurisdiction. So I have explained all. Go through this video again and again so that you may grasp the idea what I want to say. That's all. God bless you all. See you again.